Okay, great.
The committee will come to order. I'd like to recall Secretary Artman, please, if you could. We have some questions from the gentleman from Oklahoma that wishes to ask Secretary Artman, and gentleman from Oklahoma.
Thank you, Mr. Chairman. I appreciate you all coming back. Got just a few questions. I want to make sure I've got these in front of me here. Well, one of the first questions I have, without looking at my questions, was you mentioned that there are 4 teams looking at 17 different petitioners. And can you talk a little bit about what comprises these teams? How many people are in these teams, and what do they actually do? If you could touch on that first, then I've got several more questions.
Thank you for your question, Congressman. Actually, I'm going to defer to the Director of the Office of Federal Acknowledgement to answer because he can do it in much better detail.
Each team is made up of an anthropologist, a genealogist, and a historian. And the teams then look at the evidence of a group. Under the regulations, the team has 12 months to review all of the evidence. And we're talking between 10,000 to 30,000 pages of evidence. And it's not the quantity, but it's the quality of the evidence as it is applied under the 7 mandatory criteria. At the end of the 12-month period, the team provides a proposed finding, either to acknowledge the group as an Indian tribe or to deny acknowledgement as an Indian tribe. And the proposed finding outlines how the evidence has fallen under the 7 mandatory criteria. When notice of that proposed finding is published in the Federal Register, that starts a 180-day comment period for the petitioner and interested parties and the public to see what is being proposed. And comments are then provided by the petitioner or interested parties or Jane and Joe Q public. And at the end of that 180-day comment period, then the petitioner has 60 days to respond to any of those comments. At the end of that 60-day period, or 2 months, then the department, again, comes back with the team to review all of the comments and the responses and the evidence to come out with a final determination. And again, the final determination is to acknowledge or not to acknowledge the group as an Indian tribe. At the end of that period, notice is published in the Federal Register, which then allows a 3-month period to allow the petitioner or interested parties to request reconsideration before the Interior Board of Indian Appeals. You add all of those regulatory time frames, and it comes to 25 months as a regulatory review. It also provides the due process to the petitioner and interested parties, and all of that is taken under consideration.
So again, these 4 teams with a little over 2 years with all these time limitations, are these teams looking at, as was mentioned, 17 different petitioners? Are they doing simultaneously? Are they handling 3 or 4 different petitioners? Are they just handling that one and then going to the next one after the 25 months are done?
Because of the different phases, the 12-month period, they're focused on just one petitioner to come out with that proposed finding. When it goes into the 6-month public comment period, then they're able to switch to work on another case, generally perhaps a final determination, which takes a lesser time to produce. So there's a give and take with how the teams work.
Well, since it looks like I'm getting the yellow light, let me go quickly to the money issue. Secretary Artman, you brought up the fact that we need more money. How much more money do we need if we need to hire these, more teams to handle this caseload? A, how much money? And then 2, you also mentioned that timelines are beneficial. One of the answers to Congressman Cole's question was timelines are beneficial. What are the time limits? What should they be if you were writing the rule book? And so those two questions, money and time, what would be your answer?
With regards to the money question, I think one of the first questions we have to ask ourselves is how quickly do we want to get through this? Years ago when the GAO did their report, they had a similar statement that you're going to need more money to hire more teams to complete this. And in looking at that issue, internally we did a study and determined that if we want to get this done, I think it was in, say, 5 years in that respect, we're going to need to hire 15 teams. That's a huge ramp up from where we currently are. And to do that, you're now looking at, certainly something north of $15, $20 million. Is that the right number? Is 5 years the right number? What's the urgency that we need to put on this? There's certainly, this is something that is important that needs to be done. So we need to make that determination first. That number can fluctuate depending upon how many teams we end up at. With regards to the deadlines themselves, we have one of the things that we're looking at internally, as I mentioned before, we're looking at doing guidelines, regulations, and perhaps making legislative proposals. As we're looking at those, we are looking at those deadlines. As you look at the number of 260 applications, there are 243 that don't have complete petitions or are only letters of intent. As this body here looks out at that and says, my goodness, you have a backlog of 260 applications. I don't know that's necessarily true. We have 17 that are certainly under active consideration. We have another 243 that aren't complete. How long do those linger on that list? How long? Many of those have been there for decades.
That's where you mentioned the petitioners having a timeline as well. Is that
right? Exactly.
Okay.
And I think certainly on ourselves, no issue. There has to be deadlines for the various stages that we have, and I'd be happy to get you a more detailed study that we've gone through it as to what those deadlines are. But certainly with regards to the petitioners as well, we want to see deadlines on those individuals to promote getting the material in so that we can have that consideration and so we can better determine how many teams that we do need to have. There are a lot of questions out there that have to enter into the equation to get that final answer that you first asked. How about the money? And this is one of those questions, is how many do we really have out there and how quickly do we want to go through these?
Okay, I appreciate that. I've run out of time, Mr. Chairman. Thank you.
I thank the gentleman from Oklahoma. Ms. Sadlin? Questions?
Thank you, Mr. Chairman, and thank you for your testimony. I apologize for not being here earlier. We were in a Veterans Affairs Committee hearing on the future funding of the VA, and I think that with the oversight which our various committees are tasked to do, I'm pleased that this committee has been more aggressive in the oversight in the 110th Congress of various agencies, and I think the same question that perhaps goes beyond the particular bill we're discussing today, and I know you had spoken before I got here about some internal reforms you're looking at when you came on board earlier this year to expedite the process, to make it work more effectively for petitioning tribes. But I think the question beyond that, that's an important one, is the future, the funding for the future of the BIA. Mm-hmm. And if you could talk a little bit, and maybe you have in response to some other questions, as we're dealing with potential internal reforms, differing ideas about the particular bill that's been introduced to address the process, concerns of petitioning tribes, if all of the majority of the Indian groups who are presently petitioning for federal recognition are federally acknowledged, how, if at all, will other federally recognized tribes be affected? In other words, what are the impacts that the BIA will experience, and are you addressing those sort of simultaneously as you're looking at the internal reforms that you discussed previously to ensure that obligations of the federal government in the sovereign-to-sovereign relationship that we have with currently recognized tribes that we will have in establishing the recognition process for petitioning tribes? Can you elaborate a bit on what the impacts will be and how you're seeking to address those as well?
Sure. And this is a very good question. This came up in the previous hearing a number of months ago when we were looking at the bills that concern the Virginia and the Lumbee tribes, because those were questions that we wanted considered here in this forum, is the impact that that would have on the budget. Earlier, there was a determination that if every tribe on the list, all 260 plus the 61 that had not been recognized, had all been recognized, that you could potentially have 320. I think that's probably a very high number compared to what the reality would actually be. But just working with that large number, you're going to be looking at tens, hundreds of thousands of people that would be coming, individuals under those tribal rubrics, that would be coming onto, that would require some additional funding from the federal budget. At this time, we're already drinking out of a fire hydrant in terms of need and not being able to fulfill all of it. And that's with the 562 recognized tribes. The 562 recognized tribes with about approximately 2 million people, you have a budget that already amounts to $2.3 billion just for the Department of the Interior and Indian Affairs. My peers over at, I'm the Assistant Secretary for Indian Affairs. Beneath that in the organizational chart is the BIA. And if I didn't recognize that the Bureau of Indian Education is no longer under the BIA, so we have two bureaus now, Bureau of Indian Affairs and Bureau of Indian Education. The education folks would be irritated, so I've certainly put their marketing out there. And so we have to look at both of those, both the BIA and the BIE. That's $2.3 billion just for the Department of the Interior on Indian Affairs. We also have HHS through IHS, HUD and the NAHASDA program, Department of Transportation and the Indian Reservation Roads program, Department of Defense, and some of the other agencies out there also have funds that are dedicated to Indians. I think that would also increase, probably in a linear fashion, with the number of tribes and individuals that are recognized. That would be the hope. That would be the hope. But even with increasing populations and increasing tribes, other priorities and other pressures on the budget haven't allowed that budget to increase or even stay competitive with the cost of living or inflation. And so we find ourselves each year looking at a more and more limited budget. And now we're at the point, we're asking a question that should be asked. Even if we had more money, this question should still be asked. But now we certainly have, it's an even more imperative question. How do we operate more efficiently to continue to deliver the mission, goals, and services? I think if all 320 were recognized, or even a third of that, we'd have to ask that in an even more serious manner, and certainly we would require much more funding than we currently have.
Well, I appreciate your response, and Mr. Chairman, again, I appreciate the opportunity to participate in the hearing today. As a representative of 9 land-based tribal nations recognized through treaties with the U.S. government, I'm acutely aware of the importance of tribal sovereignty. And when I meet with tribal members and leaders in South Dakota, I understand the desire to have the proud history of tribes recognized and respected by the federal government. And I appreciate the difficulties that have been encountered by American Indian groups seeking federal recognition, the frustration with the processes that exist today. And I also understand the solemnity of the government-to-government relationship and the United States trust responsibility established by the treaties and various congressional actions. But at the end of the day, I believe that the administrative processes to federally recognized tribes must be sufficiently robust to ensure the integrity of this relationship, and that we are committed to simultaneously addressing our oversight responsibilities as it relates to the BIA's budget, as well as the budgets of other agencies responsible for ensuring that the commitment to each tribe is fully recognized and respected, and that those obligations are fully funded as well. So thank you, and I appreciate the opportunity again.
I thank the lady from South Dakota for her, her remarks. Maybe I'm being too simplistic sometimes, but we're spending $10 billion a month on the war in Iraq and Afghanistan, and here we're barely trying to provide $2.3 billion for a whole year to provide for the services of our Native American community. It just puzzles me a little bit. The gentleman from Michigan.
Just one comment, Mr. Secretary. I appreciate your testimony. We ask tough questions up here, but I think we all are seekers after justice. But you mentioned the other programs that are Indian dollars. Some of them are, but I have 2 citizenships. I'm a citizen of the United States, and I'm a citizen of the state of Michigan, and they bring to me certain rights and certain obligations. Native Americans, I think that includes yourself, have 3 real citizenships. They're citizens of the state in which they live, they're citizens of the United States, and they're citizens of their sovereign tribe. So some of the dollars you mentioned really flow to them not so much as they're Indians, but they're Americans, right? The defense dollars. Mm-hmm. So you can't add all those dollars up and say this is what we give to the Indians, because many of them they receive as citizens of the sovereign United States. And so I think we have to distinguish certain programs. Even NAHASDA, which I'm chief sponsor of, while it's directed towards Indians, they probably would be getting some of those dollars through the regular HUD program. So I think we have to be careful of what things we add and say these are Indian dollars. Some flow to them as citizens of the United States. But I do appreciate your testimony, Secretary. Thank you.
I just wanted to, Mr. Secretary, you said that there are 562 tribes equivalent to 2 million people. I was under the impression the total population of our Indian country is about 4 or 5 million. What happened to the other 2 million?
I've seen about 6 or 7 different numbers.
Take your choice.
Exactly, and that's a mid-ground.
So does this mean that we're actually providing for only 2 million Indians of the
No.
$2.3 billion?
The way the federal budget and the relationship with the tribes works, I mean, we don't look at it as a one-to-one. Here's how many dollars are going to this individual Indian. Because of our government-to-government relationship, we don't even get beyond that government question. We know how much money goes to a particular region or a particular tribe for a particular project. But the population of that tribe, we don't get into a dollar, how many dollars per individual. We don't even ask that question. I don't think that we should either, because of the government-to-government relationship. That's the floor.
No, I understand the government-to-government relation, but I'm still a little puzzled here. What is the real population of Indian country out there? You're saying it's only 2 million people, and I'm saying there's 4 to 5 million Native Americans living in the United States. And of course, we recognize the fact that some 100-some tribes are not recognized. So I'm looking at only for those who are recognized, and you're saying there's only 2 million of them.
There's a census, and then each tribe also determines its own, how it views citizens, what it views its membership. There is no standard across the board. And then there's also like you said, the tribes that aren't federally recognized. Those individuals view themselves as Indians, rightfully so, and put that down on the census. So it's a moving number.
Could
as to
I-
how many there are out there, and how many we actually impact through our federal funding.
Okay.
Would
You'd
the chairman
indicated-
yield? Would the chairman yield?
I gladly yield to the gentlelady.
This is a very important line of questioning the chairman's pursued here, because again, relating back to some of my earlier questions, and then how we, through the federal recognition process as well, would you agree or disagree with the statement that the census has traditionally undercounted the number of Native Americans living on the various reservations across the country?
I don't know. I'm not familiar with the processes that the United States Census Bureau uses, nor am I an expert on determining whether or not that is the way to count it.
But are you aware that certain tribes have undertaken, I think you referenced it,
Yes.
certain tribes have undertaken their own census of sorts, their own counting, because of their concerns that the U.S. Census has traditionally undercounted? And have you considered that as it relates to the internal reforms you're looking at for the recognition process, in terms of, I mean, which does your agency defer to when you're looking at the budgets, the programs that you administer? Are you deferring to the U.S. Census? Or are you showing some deference to the tribe's own census counts for their population of enrolled members?
And again, to go back, in so many aspects, our question stops at the tribal government. And the tribal government may be made up of 6, I'm sorry, the tribal membership of that government may be made up of 6 people, 6 citizens altogether, or it may be made up of 250,000. But we don't spread out the money evenly across the tribe. Obviously, the size of the tribe or the program that you're trying to fund, which is oftentimes determined by the size of the tribe, determines how much money you receive. But have we gotten into the question of which is the best way to count which numbers we're going to view as the accurate count? Not for the purposes of recognition, we haven't. No.
Okay, thank you, Mr. Chairman.
Mr. Secretary, I'm totally confused now.
Almost.
The census has a different counting of Native Americans, obviously, so the Department of the Interior also has a different counting. You're saying you count by programs and not necessarily in numbers. I would think that the reasons for the $2.3 billion is because we have to provide for some 4 to 5 million Native Americans. I assume that among the 562 tribes that this is what's being officially recognized. You're saying there are only 2 million of them out there. That's almost 100% less than what I've always understood it for the last 10 years, the increase or the number of Native Americans in the U.S.
We can provide you a list
Could you
of various
please- yeah,
numbers from the various different
Please.
areas that we also have
I
access to,
would
including
appreciate-
NCAI and NIGA.
I would appreciate if you provide that for the record. I have one more question. Who decides which anthropologists and genealogists and historian make up the team? Is this in consultations with the petitioner tribe, or is this something that the division of the federal acknowledgement process makes the ultimate decision as to? Because what happens if the genealogists or anthropologists say, hey, I've written some stuff about these guys and they're not for real? It's already prejudiced before they even started doing the research.
I, as director of the office, we have the anthropologists that have specialties in different areas of the United States. If a group falls in the Northwest, I look at the available staff members to see if one of those staff members has this expertise in that region, which would help in the understanding of the evidence. So it's a management decision to take a look at which staff members are available when a certain case comes forward, and we assign, and we focus on the 7 mandatory criteria.
I don't question which staff is available. What I'm questioning here is that how can we assure that this anthropologist or this genealogist or this historian is going to be neutral in its efforts to come out with the facts and data, and not already said, hey, I've written a book or some articles about this group, and I seriously question their petition as a tribe.
The regulations require that we notify the petitioners as to who is going to be assigned to the case, and then when the proposed finding is issued, the petitioners and interested parties have the opportunity to request an on-the-record meeting to discuss the review, the analysis, the evaluation of the proposed finding, and if there are questions regarding some of the staff who were assigned, that's an opportunity to ask those questions.
Okay, well, that's the reason why I asked. There is consultation with the petitioner and the division of FAP. Am I correct on
Well,
this?
we notify, yes.
Yeah. Notify, but not consult then. In other words, if the petitioner doesn't agree with the anthropologist, you're still going to go ahead and proceed and appoint that anthropologist.
We work with a team that we hope would be able to expeditiously review.
No,
within
that's
the
not what I
12
asked.
months.
You're still going to appoint that anthropologist. I mean, it's your discretionary authority to make that appointment, right?
Yes.
Okay, that's what I wanted to find out. Well, Ms. Secretary, this has been a long morning for you, and I do apologize if we've taken you so much of your time, but I promise you this will not be the last time you'll be seeing us.
You haven't taken too much
So
time. I
we do really
this.
appreciate your coming this morning and to testify, and look forward in working with you and your office.
And I appreciate your questions.
Not just
and
to this
unfortunately, I
piece
won't
of
be able to stay for the next 2 panels, but I'm going to ask my staff to stay, and I'll be speaking with them later.
And I'd like to also say for the record, the committee will submit written questions, both from the members as well as the committee, and would really appreciate if you could respond as soon as possible, made part of the record.
And I would hope as part of those written questions that one of them will explore the Department of Justice issues, and we'll get you a fuller explanation of that. You know, we
Could
got
you
some
please?
information on the
Yes.
break, but we'll be happy to.
We
submit
would
them in
really
written.
appreciate that, yeah.
Thank you.
Yeah, you can bet your bottom dollar. Is that how they say it? I'm still learning English here, so is that how they say it?
That'll work.
Bet your bottom dollar? Okay. Thank you, Mr. Secretary.
Thank you.
We have as our next panel, I'm sorry for all this time, Ms. Patricia Zell, the president of Zell and Cox Law Firm in Washington, Ms. Arlinda Locklear, also an attorney here in Washington, Mr. Mark Tilden, the staff attorney with Native Americans Rights Fund, and also Mr. James Keedy, executive director of the Michigan Indian Legal Services in Michigan. I would be more than happy to give the time to the gentleman from Michigan for introduction of one of the members of the panel.
Chairman, I'd like to particularly welcome the entire panel, but Mr. Keedy, Executive Director of the Michigan Indian Legal Services, Traverse City, Michigan. My father was born near Buckley, Michigan, and when I was about 7 years old, about the time I made my first Holy Communion, my dad told all of his children that the Indians had been treated unfairly, and that stuck with me. And the first time I could do anything about that was 1965, when I was elected to took office in the state legislature, introduced two bills, one establishing the Michigan Indian Commission, and the other, Senator Jackie Vaughn and I introduced a bill, the Michigan Indian Tuition Waiver Act. For any Michigan Indian can attend a public college in Michigan, and the state pays the tuition. But I particularly greet you here. The Kildees arrived as immigrants from Ireland and settled in that area. And I'm glad that my dad had that type of conscience that he could recognize and pass on to his children that the Indians were treated unfairly there. And I appreciate your presence here today. Thank you very much. And thank you, Mr. Chairman.
Gentleman from Hawaii.
Well, thank you very much, Mr. Chairman. I do want to take advantage of the opportunity to introduce Pat Zell. I'm doing this by way of full disclosure, too. While I did not arrange for Ms. Zell to be on the panel, I wouldn't want to let the opportunity pass to express publicly my gratitude to her for, although she may not want to say it publicly, more than a quarter of a century of friendship and what's more important, information and perspective provided to me that has been invaluable. I won't repeat all of the qualifications that she has to be here today, as they're apparent in all the members' files here, but suffice to say that the Senate Indian Affairs Committee was dependent upon her service, her insight, her perspective for the better part of 25 years, and most important from the point of view of the legislation, the particular legislation that's before us today. I don't think we can find anybody that has a better legal perspective on the value of this bill and its direction and its legislative intent than Ms. Zell. So I'm taking a little bit of time, but you don't often get an opportunity, Mr. Chairman, to say in public and in the legislative context how valuable it is to us to have people working on a staff level that provide the foundation for our legislative activity. We live in a kind of a closed universe in here, sometimes maybe a parallel universe to the real world outside. But our real world of legislation is utterly dependent upon the professionalism and the dedication and the perception of people like Pat Zell.
I would, not taking anything away from Mr. Tilden and Ms. Locklear, but I do want to second the comments made by my good friend, the gentleman from Hawaii. And I just want to say, Afan Yata'e, to Patricia Zell, who's with us for the first time. She'll be testifying before our committee, to my distinguished colleagues. Needless to say, her legislative accomplishments are too numerous to name, from the National Museum of the American Indians to Indian health care, the tribal water rights, and of course the Native Hawaiian rights. And I cannot say enough to say how much you're well respected, Patricia. And I know that I speak for my colleagues, the tremendous service that you've given not only to Indian country, but certainly to our nation. And with all that said, let's get it moving. Patricia, could we have your testimony first?
Yes, thank you, Mr. Chairman, and thank you for your very kind remarks, Mr. Abercrombie and Mr. Chairman. I don't know that they're deserved, but I certainly appreciate your respect, truly. Mr. Chairman and Congressman Abercrombie and Keedy and Boren and Salin, I thank you for the invitation to present testimony today on H.R. 2837. The thoughts that I share with you arise out of my work on the Senate Indian Affairs Committee, and particularly very intensive work toward the end of my tenure there, which ended in May of 2005. The information that we gathered in consultation with the Office of Federal Acknowledgement and the General Accountability Office and the Inspector General's Office of the Department of Interior, and tribal groups having gone through the process and those that were in the process identify problems that continue to plague the process. So in that respect, some of these issues remain timely because the problems haven't changed significantly over time, sadly. I want to inform the committee that our law firm has no clients in the acknowledgement process. I think that the provisions of H.R. 2837 represent a very thoughtful approach to this whole range of issues, and I thank Chairman Faluma-Mavenga for introducing the bill and for his perseverance in pushing this bill forward so many times. As you can imagine, over the course of my time in the Senate, we held many, many hearings, oversight hearings on the federal acknowledgement process and the need for reform. And many members, some members of the Senate have consistently adhered to the position that rather than the Congress taking any further legislative action to extend recognition to a tribe, that the federal acknowledgement process ought to instead be reformed and that all tribal groups should go through the acknowledgement process. However, that promise of legislation to reform the process has proven to be illusory. There's been legislation introduced in every session of the Congress, but all these years later, we have nothing to show for it except good intent and a lot of good work and effort gone into it. So I'm very hopeful, as I know many of those in this room and those whom they represent, we are hopeful that there will finally be action to provide support to this process, whether it's more resources at a minimum or whether it's comprehensive reform as this legislation proposes. It's long overdue. It's very much needed. And I think that what we know, those of us who've worked with this process for a long time know, is that these petitioning groups are disenfranchised to some extent, to the extent that the federally recognized tribes can gather around an issue, and if there's consensus, they can speak with one voice. All of these disparate groups that are in the process have no means of coming together and speaking with one voice, nor do they have the means by which to call the attention of members of Congress to this issue and to these problems associated with the acknowledgement process. So you've given them a voice, you've given them a forum, and that is very important in and of itself. I want to say that in our consultation with those federal groups and General Accountability Office and Inspector General's Office and the Office of Federal Acknowledgement, we of course had that consultation. within the confines of knowing that they are not authorized to make legislative recommendations. What we asked of them was to identify through their experience what they thought the problems with the process are. And I'm now going to speak very fast because I see the yellow light is on. Two things. The Office of Federal Acknowledgement staff is tasked with an enormous amount of responsibilities. They ought to be divested of those responsibilities and given one task, which is to work on those petitions and get them processed. The technical assistance function, which absorbs an awful lot of time, could be posited in another entity so that the technical assistance, a very important function that the government serves to help tribes, help petitioning groups, could proceed, but not be taking the time of the acknowledgement staff, whether they're in Interior or in this new commission. We suggested the possibility of exploring placing that technical assistance function in the Cultural Resource Center of the National Museum of the American Indian, where so many documents and records that tribes and petitioning groups seek and rely on anyway, they are going there and using that information to document their petitions. Perhaps that is a good place to house technical assistance. The second thing is not to separate out both that technical assistance function from the decision-making function, because we are all human, and if we spend a lot of time providing technical assistance to a group, and then by one way or another later are called upon to make some decision about the merits of that petition, that's just difficult. You're just ultimately evaluating your own work if you've provided a lot of technical assistance to a group, and that's not a good position to put anybody in. So I'll just summarize. I think that we need to take away, whether in a commission or otherwise, those things that draw upon the time of those experts, the historians, anthropologists, genealogists that Mr. Fleming has spoken of, and let them do their work. Put the other tasks to on other entities and to other people. With regard, the last thing I want to address is that in recent years there have been a lot of allegations, particularly as they're associated with gaming, that this process is subject to external influence. And one of the things that we talked in depth about with all of those entities, federal entities that I just referenced, was whether or not there ought to be a point in time where, if in this case the commission, the petitioning group, and interested parties would file something with a federal court, likely in Washington, D.C., and the court would then supervise the process of each petition. That is not a day-to-day activity, but it would basically do, as the court has done for some groups that have petitioned the court, to set some deadlines so that everyone has an idea of how long this is going to go, when certain things are going to happen, and to assure that one petition isn't taken out of order because the court has directed the Office of Federal Acknowledgement to work on petition A when petition B was really the one that was ready to go forward. So we think that putting it in, or I don't suggest that it's a personal view, but rather a suggestion that if you had court supervision of each and every petition, you might provide a means for extricating any possibility of external influence on the process, as well as providing an orderly process, including not having interested parties come in at any point in time that the process, a particular petition is being considered, and taking up the time of having to reproduce documents and bringing those interested parties up to speed. So I thank you again, Mr. Chairman, for the opportunity to present testimony today.
Thank you, Ms. Zell. Mr. Locklear?
Thank you, Mr. Chairman. I appreciate and welcome the opportunity to appear today on this important bill, H.R. 2837. I have worked on this issue for approximately 30 years now and have had, during those years, the extreme pleasure of working with you, Mr. Chairman. On behalf of all of us who labor in this field, we express our extreme gratitude to you for your faithfulness in your effort over many Congresses in trying to bring fairness in this process to all non-federally recognized tribes. So thank you for that, and we hope this effort succeeds. Let me start by saying most of the testimony that the committee has heard this morning has focused on the procedural aspects of the question of how does one go about determining whether an Indian tribe exists. Is it done by the BIA? Is it done by an independent commission? Do there need to be timelines? Those are all important questions. Other witnesses who will testify on this panel will speak more specifically to the procedural questions. Let me say, though, that I do strongly agree with those you will hear soon that the process needs to be taken entirely from the hands of the Bureau of Indian Affairs, as H.R. 2837 proposes, and placed in the hands of an independent commission. With respect, I think the committee heard today in the testimony of the Assistant Secretary himself the reasons for that. The BIA has an important mission, and that mission is to serve federally recognized tribes. As Mr. Artman correctly pointed out, the Bureau holds a trust responsibility to those tribes. That is as it should be. However, it asks too much to expect that same institution to apply the recognition process in an even-handed manner to tribes on the outside, tribes for whom it does not have a trust responsibility, tribes for whom the recognition may impact the services it tries to extend now to presently recognized tribes. For all those reasons, I would urge that the committee proceed with all of the provisions in H.R. 2837 that authorize that independent commission. In addition, though, and I also strongly believe this, the creation of the commission does not solve the problem. That's only half of the problem. If you transfer the existing regulations now to an independent commission, eventually that independent commission will be bogged down in the same minutia of examination of tribal histories that the present process engages in. So to make the fix work, the committee should also focus on what those criteria are. In those respects, I would like to make some specific comments, some specific suggestions, as well as propose some particular amendments to 2837, H.R. 2837, to ensure that not only is the process where it should be, but that the process works as it should be and is looking at the relevant criteria. First, let's begin with what I consider a fundamental flaw in the process, and that's its extreme time depth. As it now functions, all of the 7 mandatory criteria, except for criterion A, require proof of continuity from the time of first sustained white contact. In the case of many Eastern tribes, that could be 350 years. More importantly, that is not necessary. The question before us is this a legitimate Indian tribe? An Indian tribe is a body of indigenous people who exercise inherent authority. It is not sovereignty that was delegated by European power upon discovery. It is not authority that was delegated when the Constitution was adopted or the Declaration was signed. It is inherent authority. So the time of white contact is legally irrelevant. The inquiry need only be, have they existed long enough to establish their legitimacy? In my view, H.R. 2837 makes a great progress on that point by establishing the beginning point as 1900 for all the criteria. Arguably, we could bring it even sooner, and some witnesses support bringing it sooner, but certainly 1900 is a fair and reasonable approach that will streamline the process and save a lot of time and resources. That's the most significant flaw. Secondly, though, and I urge the committee to look at the criteria themselves, the criteria are written in a way that encourage subjective analyses of minutia of tribal communities and internal relations within the tribe. Let me give you some examples. The community criterion, known by shorthand as B, by those people who exercise the authority to make these decisions. The B criterion requires a petitioner to establish that there is significant interaction among a substantial number of community members. Mind you, this is an examination of internal relationships among the members of the tribe itself. Not only do they talk to each other, but how often do they talk to each other, and what do they talk to each other about? There's one case, for example, that illustrates this problem, where the tribe actually had to produce telephone records of individual members to prove how many members each member talked to and how often those members were talked to. That's the level of detail that takes a very long time to examine, and that needs to be fixed. We need objective criteria. Similarly, for criterion C, political authority. Political authority is defined as, in the regulations, as a relationship between the leaders and the followers. In other words, are there significant issues on which a majority of the members will defer to the leadership of the leaders? This is referred to by the Bureau of Indian Affairs as bilateral political relations. That's their shorthand term for the phrase. Again, though, it focuses on the internal dynamic of the tribe. It requires the tribe to document that it makes decisions, it has leaders who make decisions that affect the lives of individual members. That takes time and that takes resources. And again, it is not necessary. If a community exists, then that community must have leaders. And if they can identify those leaders and describe for the decision maker how those leaders are selected, that should be all that should be asked of them. Finally, and I see that I'm out of time, I will very briefly describe one other idea that I think may serve to shorten and streamline the process for all tribes. The Bureau discussed earlier the idea of an expedited denial, an expedited unfavorable for certain tribes that clearly cannot meet the standard. That makes some sense. It makes no sense for a tribe that can't even prove that its members are Indians, for example, to go through an analysis of significant community interaction. That makes sense. However, on the other side, in all fairness, there should be an expedited favorable for certain tribes that all of us looking at it can see and tell plainly they are Indian tribes. Let me give you some examples. Number one, if a tribe can prove that its present-day members descend from a tribe that was recognized by treaty with the United States, that ought to be the end of the inquiry. That tribe should be entitled to a presumption of recognition. Another example, if a tribe can prove that it occupies a reservation that the state has held and governed as belonging to those people since 1900, a state-recognized reservation since 1900, those folks ought to be recognized. It is counterintuitive to suggest that there's no community or political leadership. Those are the kinds of things that if those, let me give one other quick example because it shows how easily this can be done. Third example, if a tribe has been determined to exist as an Indian tribe under federal law by a federal court, there's no reason for the BIA to make the detailed examination on community and political authority that it does. That tribe should be entitled to recognition, end of story. So if the BIA is able to parse down its list of petitioners through those means, both favorable and unfavorable expedited consideration, that will streamline the process as well. In sum, we've reached a point where we have a process, and we can all debate as to how it got to this point, where there is so much focus on the individual tree that they really are not able to see the forest. But in all of these cases, all of us, if we step back, the lines and the contours of the forest are visible, they're palpable, they're there. It is not that difficult to see unless you remain focused on the individual tree. If we reform the process, we must reform the criteria so that we alter that focus, so that we can allow all legitimate tribes to be recognized as such. Thank you.
Thank you very much. Mr. Tilden.
Good afternoon, Mr. Chairman and members of the committee. My name is Mark Tilden, and I'm a staff attorney with the Native American Rights Fund, and we are legal counsel to the United Houma Nation, the Shinnecock Indian Nation, the Pamunkey Tribe of Virginia, and the Little Shell Tribe of Montana. And we have worked on all of their petitions for federal acknowledgement. And today I have accompanying me one of the trustees from the Board of Trustees with the Shinnecock Indian Nation, Mr. Lance Gumbs, who has testified before this committee on prior occasions. To begin, the administrative acknowledgement regulatory process is only one pathway for Indian tribes to obtain federal recognition. Under the federal Constitution, the Congress has broad powers to recognize Indian tribes. So this morning was a little bit of a surprise to hear that the Department of Justice has perhaps inquired into the scope of Congress's powers, and I'm curious to see what the outcome of that situation is about. Courts also possess the power to recognize Indian tribes, and Congress made this unequivocally clear in the Federally Recognized Tribe List Act of 1994, when it expressly stated in the legislative history that Indian tribes presently may be recognized by a decision of a United States court in addition to recognition through an act of Congress or through administrative proceedings. And the powers of Congress and the judiciary to recognize tribes is not hypothetical. They both have been used when the situation calls for it to fulfill their constitutional responsibility. And the Congress has found it appropriate 11 times since the promulgation of the acknowledgement regulations in 1978. And this track record virtually matches the number of tribes acknowledged by the administration, which amounts to 15 acknowledgements. And Congress has not hesitated to recognize Indian tribes through special legislation. And I urge this committee not to abdicate that responsibility, but to follow the precedent of recognizing Indian tribes legislatively when appropriate. Turning to the judiciary, it too has exercised its power, including after the enactment of the acknowledgement regulations. 25 California tribes from 1978 to 1992 received a judicial determination of their status, and those tribes are now on the list of recognized tribes. Most recently, on November 7th of 2005, the United States District Court for the Eastern District of New York issued an order based on a full factual record developed in extensive contested summary judgment proceedings and expressly determined that the Shinnecock Indian Nation plainly satisfies the federal common law standard for determining tribal existence, that the Shinnecock Indians are in fact an Indian tribe and recognize the Shinnecocks as a tribe. Yet the Department of the Interior has wrongly refused to place the nation on the list of federally recognized tribes. And this inequity should be addressed by the Congress because the Congress has stated that judicial recognition is a legally acceptable method of obtaining federal recognition. And I think I would follow up on Arlinda, Ms. Locklear's comments too about, there's a certain point in time when I think it's really, it could really speed up the process if the department were to take the position that tribes that are federally recognized by a federal court or even by a state Supreme Court, like in the case of the Little Shell Tribe of Montana, that that's the end of the process right there. They are a federally recognized tribe at that point in time, and that should be the decision itself that they can be placed on the list of federally recognized tribes. Turning to H.R. 2837, it's unfair, it's extremely slow, and it's very, very expensive for the petitioners. And I think the one thing I'd like to really point out here is how expensive it is for petitioners. In our experience, the petitions now cost over $1 million of out-of-pocket expenses, and that doesn't include attorney times. So when the administration is sitting here talking about additional funding, I think the other point to be made is that tribes also need additional funding. I mean, if it's going to cost millions and millions of dollars, where do tribes get that money? Before, the Administration for Native American was providing some funding to tribes, although it was limited, but now they really don't provide any funding at all. That type of funding has really stopped altogether for tribes, and so a lot of tribes have had to turn to gaming developers out of necessity. Unfortunately, the fact is that source of funding has been used against tribes. And I can say this for a fact that all of my clients, and I think a lot of the petitioners, really started the process way before the Indian Game and Regulatory Act was even thought of. And I think the other point, too, that I wanted to make was there was a comment this morning by Congressman Duncan about this gaming situation and the fact that a lot of tribes may have started to the federal or may have submitted a petition for federal recognition or a letter of intent. But I think the one thing that really peaked was in the early 1990s when the administration held meetings, and that they really solicited the input of non-federally recognized tribes. They held 2 meetings at the White House where they invited all the non-federally recognized tribes. And at that point, the Branch of Acknowledgement and Research did a lot of outreach to really welcome tribes to submit letters of intent or petitions for federal acknowledgement. And so there was a peak around 94 or 95. And so I don't think it was a result of Indian gaming. I think it was a result of some of these meetings that were held by the White House, as well as the outreach that was done by the administration. Again, the other problem is that it's incredibly slow. The BIA has said that it takes about they decide 1.3 decisions per year. That's come out in the past. And for some, and at that pace, it's going to take a very long time. I can give you one example. The United Homa Nation, they filed their petition in 1985, and that was over 20 years of waiting. And they submitted a response to their proposed findings in 1996. And so that's over 10 years of the tribe waiting for a final decision on their petition for federal recognition. So there's a lot of inherent problems with the federal regulatory process, and I submitted written comments, and if those could be made part of the record, and I spelled out a lot of the recommendations that we made to help improve the federal regulatory process. Thank you.
Thank you, Mr. Tilden. Mr. Keedy.
Good afternoon. My name is James Keedy. I'm the Executive Director of Michigan Indian Legal Services, and I wish to thank the committee for giving me this opportunity to testify. I'd also like to note that Mr. Ron Yob, the chairman of the Grand River Bands of Ottawa Indians, is here today. Michigan Indian Legal Services has worked with many tribes in the past 30 years that as seeking federal recognition, and I've summarized all that in my written testimony. Today, I'd like to mention that MILS, Michigan Indian Legal Services, filed the first petition under the 1978 regulations. In fact, I have it with me here today. In this notebook is the petition, the tribe's constitution, and all their supporting documents for the petition for federal recognition. And that was filed in December of 1978. Just 10 months later, October 1979, the BIA published proposed findings in favor of recognition of the Grand Traverse Band. Contrast that with a more recent case. On December 8th of 2000, I and Mr. Yob and other members of the Grand River Bands delivered 21 banker boxes of documents to the BIA offices. And then just this year, 7 years after that petition was delivered, they were placed on the ready and waiting for active consideration list. While that is progress, it is estimated that the Grand River Bands will now wait 15 to 20 years for a decision, a final decision on that petition. Obviously, something is terribly wrong. Whatever the eventual outcome for the Grand River Bands, justice is not served by such a delay. And it is universally recognized that justice delayed is justice denied. Can this problem be fixed? I think that H.R. 2837 presents an opportunity to do that. If the problem was simply a lack of resources, Congress could fix the problem by appropriating additional money. I believe that the problem cannot be solved by money alone. The example of the Grand Traverse Band petition demonstrates that lack of money is not the problem, as it would seem clear that it costs a lot less to process this petition, and it took a lot less time than what is happening today. So that while it would be nice if money could solve the problem, it appears that there's something else going on here. I believe it's been amply demonstrated that Congress has the power to create a solution to this problem. The testimony of Mr. Tilden sets forth the many times that Congress has recognized tribes. Obviously, if Congress can recognize a tribe, it can certainly set forth the criteria and process by which tribes will be recognized. And it is very important that Congress act. The lack of federal recognition causes problems every day for ordinary tribal members. For example, Congress created a very thoughtful response to the problem of massive numbers of Indian children lost to tribes and tribal culture by adoption into the majority culture, and it created the Indian Child Welfare Act. The problem for members of tribes that lack federal recognition is that the protections of the Indian Child Welfare Act are only granted to children whose parents are members of federally recognized tribes. In a book called American Indians, Time and the Law, Charles Wilkinson remarked that in his view, the effect of U.S. Indian policy was for Native people the creation of a measured separatism. But without the benefits of U.S. policy, members of tribes that are not recognized are at risk of being overwhelmed by the dominant culture and law. That may explain the comments of a Grand Traverse Band member that I cited in my written testimony, that on the day we got recognized, we were suddenly a people. The independent commission created by H.R. 2837 is a very important idea, and one that has been suggested many times in prior hearings on federal recognition reform. Commenters today and at prior hearings have noted the inherent conflict of the BIA in supporting existing tribes while charged with determining if new tribes should split a pie in increasingly smaller pieces. But beyond that, current process has evolved, as the current process has evolved, it makes it clear that a fresh start is needed. The current process was not intended to be so burdensome. Mr. Shepard, who helped draft the 1978 regulations, has stated that petitions like the Grand Traverse Band petition were what was intended. The process needs to be an adjudicatory function of the government, and instead it resembles an academic exercise. The criteria that were the foundation for the current regulations, the, quote, Cohen criteria, cited in my written testimony, were meant to be an aid in the fact finder in establishing that the tribe continued to exist. And the fact finder only looked at those criteria to see if the tribe continued in tribal relations. They weren't used to establish that a tribe existed. The regulations in '78 completely flip-flopped that and said that the tribe had to prove that they exist now. And not only in the Cohen criteria, you looked at one of the factors, you could use in combination, singly or jointly. Now you have to meet all 7 of the factors in the excruciating detail that we were heard earlier talked about, and meet any of them to a degree of 100%. The elements for needed change, I think, are in H.R. 2837. It creates a separate commission. There's a sunset provision and funding for research for petitioners. The criteria, however, are still problematical, and we would suggest a rulemaking process to develop the criteria. The Grand Traverse Bands of Ottawa Indians share the same treaties and history with the other recognized tribes in the state of Michigan, the Grand Traverse Band, the Little River Band, the Little Traverse Bay Bands, and the Sault Ste. Marie Tribe. Political power for all these groups was derived from clans, which is very unlike the organized governments that the regulations envision. They were signatories to the 1821, 1836, 1855 treaties. They petitioned for and refused recognition under the IRA in the 1930s. They received distributions of land claim settlements and participated in discussions with Congress over payment of those claims. Yet they are the only tribe not recognized, and may not be for many years if the process is not reformed. I thank you for taking up this bill and moving on reform of the process.
Thank you, Mr. Keedy. I think we've got a vote pending on the floor, but I'd like to ask the gentleman from Michigan if he has any questions.
Thank you very much, Mr. Chairman. Mr. Keedy, the Grand River Band's petition is on the Ready for Active list grouping now. Does the tribe have any indication when the BIA will move it to the active list?
No, they've not been given any indication of when it will happen.
Do they ever communicate with you to give you any ideas whether something is stalled, or is there a give and take at all, or asking for more information, or?
Well, we've had, and Chairman Yob and others too, have had several meetings with Mr. Fleming and others in the department to, ask about those kinds of questions. It usually boils down to workload and things like that.
Mm-hmm. You talked about the congressional responsibility, and we've done that, and I was amazed today when they talked about the constitutionality of Congress acting. I mean, Article 1, Section 8 of the Constitution is very clearly gives the Congress, and the Non-Intercourse Act of 1789, I think, certainly indicates Congress's relationship with the various sovereign tribes. But in 1988, I was chief sponsor of the Locklear recognition. In 1994, I was chief sponsor of Little River and Little Traverse Band, which you're very familiar with, and I was co-sponsor of the Pokagon Band. And Congress, is the competent body, and while I agree, I think we have to really reform the system within the BIA. We should never give up our own responsibility. That's why I was surprised at the testimony this morning on that. But would you comment on the role of the Congress, Mr. Keedy?
Well, I do agree that certainly the Congress has the power and has exercised it, and I would hope it would continue to exercise it, even if this process is reformed when a proper case is put before it.
And I think that's a very good answer. I appreciate it. And the proper cases put before it, because we've had other bills here that haven't passed the Congress, and we have some who have. I think we are a competent body, and we generally act prudently on that, but I think when you read the Constitution and read the Non-Intercourse Act, you see that Congress was intended to play a very significant role in the sovereign-to-sovereign relationship there. And I thank you very much for your response. Thank you for your presence here today.
Thank you.
Thank you, Mr. Chairman.
Thank the gentleman from Michigan. I'm going to proceed and continue raising some questions. I do want to thank all the members of the panel for your excellent statements. I wanted to ask Ms. Locklear about your recommendation, which I think is well taken, that the Bureau of Indian Affairs should be in the business of providing for the 562 recognized tribes. It is, and I like to add, it is a conflict of interest that you're administering the needs of the 562 tribes, and that at the same time, you're going to consider if these other tribes seeking recognition should be recognized. And I'd like to ask the members of the panel if you agree or disagree. I happen to agree with Ms. Locklear's observation about this. Ms. Patricia? Ms. Zell?
I would agree that there is an inherent conflict of interest when you're trying to serve essentially not two masters, but two different groups, and you have different legal relationships, as Secretary Artman has articulated here today. And I think, with all due respect, he may have made the case more strongly than any of us that they are do feel obviously very much bound by their trust responsibilities, and that has to compromise both in terms of resources and dedication of time and personnel, as we've seen over many, many years, the energy and effort that's put toward helping the petitioning groups get through the process and bring an end to the process. So I think you've posed the exactly right question. Thank you.
Mr. Tilden?
Well, I would totally agree with what Arlinda had to say about that, and also to
And this is not just a legal, because this is a matter of policy.
Right, it
I think
is,
this
and
is
I
what we're
think
trying to.
just to sort of echo to what Pat said about Mr. Artman sort of making the case here for the commission, because I think he did really emphasize the fact that the BIA does have a trust responsibility to the 562 tribes, and I think he does see that in terms of funding requirements as well, because he talked in terms of priorities in funding to the federally recognized tribe, and I think we see that with only $1.9 million out of a multi-billion-dollar budget. I mean, that's budget dust compared to what I think they really could offer and give to the Office of Federal Acknowledgement to go through these petitions. And you know, it was just, I mean, it was sort of remarkable sitting here listening to him make that case, that you know that it just really presented the notion that there is an institutional bias against non-federally recognized tribes. And so it's one of those issues, I think, too, where the commission, if that were to be established, the sole focus of that commission would be dedicated to the non-federally recognized tribes, and to really sit there and to really analyze the petitions that have been submitted, and that is their sole obligation. I think the other thing that Mr. Artman mentioned, too, were these guidelines that are forthcoming. And I think the one thing that would be really important in that respect, too, is to really seek the advice of non-federally recognized tribes to some extent. And I kind of take that back to the White House meetings back in the early 90s, where they invited all of the non-federally recognized tribes, and then the BIA went and did outreach.
Oh, I remember. We met at the White House and did the whole rigmarole and produced nothing.
Yeah, I mean, it was, you know, at least they did the outreach, and I think that they tried to get the non-federally recognized tribes involved in the process, to the extent that, you know, what was taking place at that point in time, too, was legislation. And I think at that point in time, too, you had also introduced legislation to reform the federal recognition process, because there are inherent problems with it. And I think that that's where this idea of a commission, an independent commission, to take care of the institutional bias that was so illuminated upon today by Mr. Artman.
Mr. Keedy?
Yes, I certainly agree with the other members of the panel. I was struck that the opening statement is that this is a very solemn obligation of the United States to make these decisions, and contrast that with the amount of resources that are devoted to meeting that very solemn obligation.
And if I may, I appreciate Mr. Fleming sitting in for Secretary Artman, Mr. Fleming, can you submit for the record exactly the whole procedure that has taken place and how you go about in getting recognition for the tribes that do petition? The timelines, just as you had stated earlier, I would really appreciate that. Make it part of the record. I would like to get that. I don't think Mr. Kanye is going to need my symbolic vote, so I'm not going to go vote on the floor. How's that? Tremendous sacrifice on my part. There's some, I think, Arlinda, again, you mentioned that we seem to be doing this, covering primarily procedural efforts. Could you elaborate a little further on that? I mean, does the proposed bill lack substance, or do you, please, the record is open. I would welcome any suggestions or recommendations that all of you would like to make as to make improvements on the bill. It's an open door for you to do this.
The proposed bill it uses, by and large, the same 7 mandatory criteria that are now in use by the.
Does it have to be
Federal
7?
Council.
That's what I'm questioning. Does it have to be
There
7?
is an argument, as Mr. Keedy indicated earlier, that they could be made in the alternative rather than all 7 be required. At a minimum, though, and I think the bill does make some movement in this direction, at a minimum, there must be an effort made to adopt some objective standards for determining whether a community exists, whether there is political authority, so that the BIA doesn't have to expend the energy and time to examine internal processes, particularly when they are so objective. Any reasonable observer can come to different conclusions, and I suspect that happens sometimes at the Office of Federal Acknowledgement. The bill does have some language on its definition of the community criterion B, which includes the objective standard of examining the level of kinship among the members. That is very helpful, because that's a yes or no kind of answer that different observers won't come to different conclusions about, and it's also a classic hallmark of an Indian community. I would encourage the amendment of the bill to include a similar marker for political authority. For example, some language that would just say, if the petitioner can simply identify a list of leaders and describe who they are, that should suffice. That should suffice, without determining on what issues and over what period of time those leaders were able to get assent from their members. Particularly on the political authority issue, it creates the consequence where more traditional Indian communities have a harder time of establishing their existence. Because when you require documentary evidence of bilateral political relations, that is almost a vote. That's almost a democratic process that's reflected in the typical IRA constitution. In the absence of a vote, where assent is demonstrated, presumably, because that person shows up and actually registers their assent to leadership through the vote, then it's more difficult. Traditional Indian communities, though, did not use that kind of process. They used a more family-based process that depended on individual leaders who would come to the fore. So that if we can get away from the focus on, again, the internal process by use of an objective criteria, then even if you keep the 7 mandatory criteria, it at least gives petitioning groups an opportunity to do it without having to go through the internal examination the BIA requires.
I noted Secretary Artman commented about the politicization of the process in selecting the 3 members of the commission. It could be 3, it could be 5, as it was suggested by others as well. But isn't it already politicized, just the sheer fact that the president is nominating an assistant secretary?
Absolutely.
The BIA is going to be a Republican, Norway is going to be a Democrat.
Absolutely. The decisions are made at the department now by political appointees. And it's foolhardy to believe or pretend that there is no political influence that's brought to bear on that. We all know that's not the case.
Now, the bill does provide some standard, at least alerting the president when he makes his nominations, that there's careful evaluation and review of the process, so that these 3 individuals have no conflicts with anything involvement of the recognition of the tribes, that they are as neutral as it could be, and then also subject to Senate confirmation, which adds another layer of making sure that these 3 individuals are going to be top people and not not a bunch of political lackeys, if that's another way of saying it.
The bill also provides that they have set terms which would presumably tend to minimize the ability of a political outsider to influence them by threat to their tenure on the commission. And we don't have that now in the present process.
I think Congressman Kennedy may have noted this, and then I noticed in your statement, Mr. Tilden, that there are tribes that are also judicially recognized.
Yes,
Can you elaborate on this? They mean
yes,
that it's different from those who are congressionally recognized.
Right. Well, I think the one thing I wanted to point out in that respect is that the Congress has spoke to that issue already in the Tribal List Act. In the legislative history, it said that that tribes can be recognized either by
You think
Congress.
we ought to make that as part of the bill to
Yes,
give
and I
due
think that would help to, I think that would
recognition?
really help to really clarify
Okay.
that and make it very clear that judicial recognition is also one legal method of obtaining federal recognition. And it's really problematic right now because for one of my clients here, the Shinnecock Indian Nation, a federal court has made a decision that they are a federally recognized Indian tribe, yet the Department of the Interior has refused to place them on the list of federally recognized tribes. And so I think it's taken away one of the legal methods that is available to tribes.
So does this mean the tribe has to petition the court again to tell the Department of the Interior you will recognize
I mean,
this
there's a
tribe?
lot of things that the tribe has to look at right now in order to force the Department of the Interior to place them on that list of federally recognized tribes. And I think they've brought a lawsuit to make sure that the administration does what it's legally bound to do.
This means more money, more resources that have to go into the process.
That's exactly right. I mean, aside from from paying for the petition work, and I'd like to point that out as well, is just how much it costs to put these petitions together. I mean, we're talking millions of dollars now, and I think that that's where the administration, it really is placing the blame on petitioners because they're telling this Congress that, yes, if you give us more money, we can sort of go through these petitions a little quicker, but I think what they fail to realize is that it's really, on the other flip side of that, is that the tribal petitioners need more money to put together these petitions because of what's now required under the federal regulations and how the department interprets those federal regulations and, new policy or new methodologies that they seem to come out with every time a new proposed finding or final determination comes down. So every time a decision comes down, I have to take a look at that and say, well, do we need to do additional work for the petitioner because some new methodology has just been articulated within the proposed finding or final determination? So, we're talking millions of dollars now, and I think that it really needs to be forthcoming in the bill that there needs to be appropriate funding at levels that would be consistent with what it takes to put together a petition nowadays. And I think that, otherwise it's setting up the petitioners for failure.
Would you say that there are tribes out there right now who pass the criteria as you suggested, but simply are without resources to petition, even to petition? As you said, it's $1 million case. So would you say that there are many tribes out there who would love to go through the process, but they just cannot afford it?
I think just from experience, yes, there are, because our organization does get requests for assistance, and we have to take a look at the resource issues right now, and we do get requests for assistance to help tribes go through the federal regulatory process. But, if it's taking millions and millions of dollars, I mean, that could bankrupt our organization, which is a nonprofit, but yet we've stepped up to help all of these other tribes in the past, and we continue to do so to help tribes get through this process right now.
I remember years ago when I visited one of the gaming operations by one of the tribes in California, and the leader of the tribe took me on the side, and she said, it's kind of ironic. We have to buy back the land that we own. In the process, simply because there was no other way to regain any sense of stability or economically viable. It's ironic that here we've taken the lands from them, and now they have to go back and buy their land back. I mean, this is just unbelievable. I know California, as my good friend Mr. Costas said earlier, there's at least over 100 non-recognized tribes in California. What do you think of Mr. Artman's response of what I said about the fact that if there are 562 tribes and only 2 million of them, that kind of really shocked me a little bit because for the last 10 years, the population of Indian country has always been between 4 to 5 million. So what happens to the other 2 2.5 million. You mean the services are not provided to them? Is that basically the bottom line?
Yeah, I think I think that that's pretty clear that that's probably what happens. There's a lot of Indians who probably do not receive federal services and benefits simply because of the undercount by the department or by the federal government in general. So, there's a lot of impoverishment to begin with, and I think that just exacerbates that problem. And I think what's even worse is that non-federally recognized tribes, those that should be eligible for those federal services and benefits are denied those. And it's really important because I think it really gets down to this being a really critical decision that's made by the federal government and how it impacts non-federally recognized tribes. I mean, if the department were to put the Shinnecock Indian Nation on the tribal list of federally acknowledged tribes, they would be able to access those federal services and benefits. So it makes a big difference in terms of health care to their members, housing to their tribal members, all of those different things that puts bread and butter on the table and provides a roof over their heads. So it really does have a direct impact on the tribal people themselves. It's not just some ephemeral, this vague number that's out there. I mean, it's a real solid number of Indian people out there that are not being able to participate in those services and benefits, and they should rightfully be allowed to participate in those federal services and benefits.
I just don't want to point fingers at the BIA or Mr. Fleming and his office. I know they're very sincere in their efforts in trying to work the recognition process. But it comes back to the Congress. I recall the years ago when the Lumbee tribe petitioned, they got their recognition, and then Congress said, no, we can't do it right now because we don't have enough money to go around because of the other needs from other tribes. That was the reason why we never recognized the Lumbees. It's because there wasn't enough money to go around. Now the problem, causing contention, as I said in my statement, among those of the recognized and the unrecognized, the fear is that as more become recognized, less in the pot for division. But it hurts me when you say that we can't recognize these tribes because we don't have enough money to go around. Is that a good reason for Congress and for the government to say that we can't do this simply because of lack of funds? Obviously, it's not a good reason, okay?
Yeah, I mean, clearly it's no. That's not a good reason. And I think it really abdicates the responsibility that, that the Congress could exercise if it really needs to say, okay, we need to get the money out there in order to recognize these Indian tribes and to see that, they do enjoy the services and benefits that they're eligible to participate in. So, no, absolutely not. It's not a
Ladies and gentlemen, $10 billion a month we're spending in that terrible war that we've caused in the Middle East. $10 billion a month. And here we're barely squeezing the $2.3 billion to provide for the needs of Native Americans for one whole year that we're saying, well, we can't afford this, we can't afford that. Now it's cutting this and cutting that. I know more than anybody, Ms. Zell will understand and appreciate what I'm talking about, what we're going through right now. I cannot thank you enough for your most eloquent statements, and please feel free at any time to contact Marie or myself or Chairman Rahal. We need your input. Put the word out to Indian country. We will take any recommendations or any suggestions that will make this bill a good one for a go, all right? Thank you very much. We have as our final members of the panel here again, thank you so much for your patience. Mr. Derril Jordan, partner with the AndersonTuell, the law firm, and Mr. Steve Austin, the cultural anthropologist with Austin Research Associates here in Silver Spring, Maryland. Mr. Mike Lawson, the senior associate in Morgan Angel and Associates law firm, and Mr. David Cramer, the attorney, and also with the Cramers and Andrews and Cramers law firm, and also accompanied by the chairman, Mr. Donny Fry, the Confederated tribe of Lower Rogue, Coos Bay, Oregon. Am I correct on this? And also unanimous consent in the record to the testimony of Mr. Joe Courtney of Connecticut and the Connecticut Attorney General, Mr. Ricardo Blumenthal, and also unanimous consent to place them both into the record that their statements be made part of the record. Without objection, they are in the record. Gentlemen, thank you very much for your patience. This has been a long day. So let's have Mr. Jordan, can you start off with our testimony, your testimony, please?
Yes, thank you, Mr. Chairman, and good morning, and good to the Mr. Chairman and committee members. I want to thank you for this opportunity to testify about H.R. 2837. My name is Derril Jordan, a partner at AndersonTuell. I'm a former associate solicitor of the Department of Indian Affairs, and I'm also a member of the Mattaponi tribe of Virginia, which is a state-recognized tribe. So I have a lot of interest in this subject, and I hope to be able to offer some meaningful testimony to Congress this morning that will help it to enact legislation that will ensure that all legitimate tribes are able to be recognized. First, I want to say that I believe that the creation of the independent commission is an important and necessary step in the right direction. I believe that it's the only way to ensure that decisions will be made by those who are entrusted by the law with that responsibility and not the staff. I believe that experts are important to this process, but I also believe that they aren't the only people with the ability to recognize the existence of an Indian tribe. There are several criteria in the current regulations and that are also in the bill that I believe are redundant. First of all, one of the criteria is that a group must show that it's been identified as an American Indian entity on a substantially continuous basis since 1900. I believe that this is redundant with the criteria regarding community and political authority, because in order for a group to prove those two criteria, it basically has to show that it has been identified by outside parties. That's where the documentation is going to come from, by outsiders. I also think that it's an inappropriate criterion because it ignores the history of what many of the unrecognized groups have had to go through. As we've heard from a number of members of the committee and other members who are other witnesses this morning, many Indian groups basically had to lay low. They had to maintain a low profile if they were going to survive. Otherwise, they would be removed to some other part of the country, or they would be subjected to incredible kinds of discrimination. So to expect that there are records that others have identified them, well, in fact, their very existence depended on not being identified is contrary to reality. And furthermore, I also think that this criteria, it asks the question, if an Indian takes a walk in the woods and a white man doesn't see him, is he still an Indian? And it answers that question, no. There's also moccasins. There's also, I believe, an interrelationship between the community criteria and the political criteria, and I agree very strongly with the comments that a number of the witnesses have made, including Arlinda Locklear. You will not find a community without a political process, and there's not going to be a political process that's unassociated to a community. As Arlinda and others have pointed out, groups govern themselves by traditional means through kinship groups. There were not tribal councils organized under the Indian Reorganization Act with people taking minutes. There simply is no paper trail of the exercise of governance. But if you find a community, you will find that there's a political process that has created or established and enforced the social bounds that make that group distinguishable from other groups. There's also a need, I believe, in the bill for an evidentiary standard, and I believe that standard should be that a petitioner be required to show that it meet each criterion by a reasonable likelihood. The bill requires that a petitioner meet the community and political criteria, political authority criteria at a given period of time or at a given point in time. And unfortunately, the bill doesn't define what a period of time is or what a point in time is. Is it every year, every 10 years, or every 20 years? But more importantly, any number of years is arbitrary because the events and forces of history and federal policy do not confine themselves to tidy time intervals. A petitioner should not have to show that it meets a criterion for numerous artificial time periods. It should be enough that, considering all of the evidence, the petitioner has shown that it is reasonably likely that it has maintained a distinct community from 1900 to the present, or that it has exercised political influence over its members during that time. If in the alternative, petitioners are to be required to meet criteria for given time periods, I think Congress should clearly place the burden on OFA or on interested parties opposing acknowledgement to show by clear and convincing evidence that a group has voluntarily abandoned its tribal relations. Putting the burden on OFA or opposing parties recognizes that evidence to demonstrate community and political influence may not be available for certain time periods due to no fault whatsoever of the petitioner. There's two quick points that I would like to make in closing in response to some earlier testimony. Assistant Secretary Artman testified about conducting consultation on changes that they're considering to the Part 83 criteria. And I strongly believe that while it's important to conduct consultation with federally recognized tribes, it is equally important that there be consultation with the groups that are seeking recognition. This affects obviously their lives, and these decisions are final, and they need to be consulted as well. And a final point about dealing with splinter groups. The United States, the Bureau of Indian Affairs does have a role to play in helping to resolve the disputes within federally recognized tribes. I speak to that from two perspectives. One, having worked for a couple of tribes as an in-house attorney that experienced internal disputes, and the BIA is involved in that process. And as the associate solicitor, I also worked on several matters where we helped to resolve internal disputes. And I think that the Bureau and the Department have a responsibility to deal with these disputes when they arise in petitioners, because it has to decide who it is that it's going to deal with, who controls the documents, who's making the decision. So I think it needs at some point to make a decision on those bases. Thank you very much.
Thank you, Mr. Jordan. Mr. Austin.
Thank you for, turn on my microphone. Thank you for the invitation to come and address the committee today. My name is Stephen Lee Austin. I'm an anthropologist, and I've been working in the tribal recognition field for 14 years now. I have something of an interesting perspective to share in that I worked for 6 years for the Bureau of Indian Affairs, what was then known as the Branch of Acknowledgement and Research, and since 1999 I've been working as a contract anthropologist working on behalf of Indian tribes who are seeking to put together these kinds of petitions for acknowledgement. I think that the legislation we're considering today in particular has several very important elements to it. Elements that, whether this bill is passed or not, they should find their way into legislation to help improve the process. I think that the first thing that needs to be done is to set dates certain by which petitioners need to have their petitions in to the federal government, and also dates certain by which the Branch of Acknowledgement and Research, or now the Office of Federal Acknowledgement, or the Commission, if the Commission is passed, those things need to have dates certain by which everyone involved in the process will know that this issue is being dealt with in a timely fashion. Petitioners deserve timely answers. The states in which they reside deserve timely answers. The Bureau of Indian Affairs, the federal government, and individual citizens out there who are going to be impacted by these decisions deserve timely answers. I think that another aspect of this that needs to be addressed, particularly if stringent timeframes are going to be mandated by way of legislation, is to provide sufficient funding. The funding would need to go to either, again, the Commission or to the Office of Federal Acknowledgement, but you can't expect them to handle a flood of petitions coming in. Say, we set a timeline of 20 years by which we expect this process to be done. There's no way that they're going to be able to handle 200 petitions in 20 years with the resources that are currently available. We've heard this over and over again from testimony, and the committee members have also recognized it today. I remember when I was working for the Bureau of Indian Affairs, the difficulty watching the branch chief, who at that time was being told as she came to committee meetings to try and explain why the process was taking so long. She was told that she couldn't, the one thing that she could not come into this committee room and ask for was more funding. Even if she was asked directly, do you need more funding? She was not allowed to answer that she needed more funding. You ended up getting answers somewhat like we got today, though I think some of the answers we got from the Assistant Secretary were a bit more promising than ones we've gotten in the past. But they usually end up answering by saying, well, this is what the amount of money we've got, and let me tell you what we're doing with it to try and make the process work better. Unfortunately, that still does not bring any kind of finality to the process. It doesn't bring any clear answers for anybody involved in it in terms of when are these petitions finally going to be dealt with. And so I think that by providing dates certain by which these things have to be done, that calls on the petitioners to finally do their part and get their petitions done and presented. And then it calls on the government in the form of the Office of Federal Acknowledgement to do its part to resolve these petitions, to look at them and render decisions on them. That would go a long way toward helping to resolve it, but then it needs to be properly funded. And I would agree with Mr. Tilden, who was giving testimony on the previous panel, that the funding not only needs to go to the Office of Federal Acknowledgement or to the Commission, but funding also needs to be provided to the petitioners. I don't know how many petitioners there are. You asked if Mr. Tilden thought there were a lot of petitioners that could benefit from that. I know that there are several clients of my own, I can say at least 3 or 4, that would be taking a much more active role in this process, participating much more regularly if they had the adequate funding. However, there is now no funding, as Mr. Tilden indicated, from the Administration for Native Americans. There are no more status clarification grants. And I was glad to see that your bill calls for reinstituting those, because I think they play a very important role, especially for tribes like the ones I'm talking about now that do not have the opportunity to enter into a business relationship with somebody that can help them fund the research. The people I have in mind, for example, are in South Louisiana, down in the bayous south of New Orleans. They're not in a position where they'll ever be able to benefit from Indian gaming, and they really don't have anything else that they can really do to raise funding. I have been working for tribes like that, like another one in New Mexico, which is in a similar position. Perhaps not quite so desperate, but if they had a market for mosquitoes, these guys in Louisiana could perhaps raise some funds. Or if there was a way to sell rocks on the Navajo reservation, those guys could come up with some funding to pay for research. As it is, persons like myself, and I know I've got many colleagues who are doing the same thing out there, end up having to work on a pro bono basis, and a lot of that means that they get attention when I can give them the attention. They're not getting the just attention that they rightly deserve. So restoring funding through the ANA for the trust for the tribal acknowledgement status clarification grants would be a major step forward. I'm one of the few people that thinks that the criteria are probably stated about right in the current regulations. However, the other thing that I would advocate for, and this is not, I don't think, adequately dealt with either in the bill or in the current acknowledgement process, that would be calling for greater peer review by independent scholars and legal specialists in the field of Indian affairs. The Bureau of Indian Affairs Office of Federal Acknowledgement does do its own internal peer review, but I think that there's a lot of the decisions recently have been coming out a little bit on the uneven side. They're really difficult to sometimes grasp the logic behind some of the decisions that have been coming out, where evidence is seen in some years to be showing that a tribe is there, and then for another 20 years after that there's no tribe there, and then after that another 30 years there's evidence of political leadership there. I would be very pleased to present the evidence that we've had in other cases to an independent review board of specialists to say, given the standard of evidence that is in the regulations, the reasonable likelihood of the validity of the facts, would you say that that tribe was in existence for 20 years, suddenly went out of existence for another 20 years, and then came back for another 30 years and was in existence again? Is it more likely to assume that that tribe was there all along, especially when there's nothing that contradicts the fact that the tribe was there all along? It's issues like that that will drive the petitioners and scholars and attorneys in this process crazy because we feel like the decisions are very uneven sometimes. And that would also, the final thought I have that I'd like to share this afternoon would be, bear in mind that while the criteria, in my opinion, the criteria are important, and I think they should be the first line of defense or the first line of evaluating petitions that come in, there are going to be some instances in which the Congress needs to stand ready to act. And there are going to be some groups out there that are not going to be able to meet the criteria as they are stated, and particularly not as they are currently being interpreted by the Office of Federal Acknowledgement. Groups like the Burt Lake Band of Ottawa Indians in Michigan, for whom I worked, I think it's important to watch some of the signals that come out of the Interior Department on things like this when they say to you they do not oppose legislation to recognize a group, or that they are, I don't think I've ever heard them say it, but if they ever did say they were in favor of legislation to recognize a group, Congress needs to pay attention to that. In the case of Burt Lake, they went through the process. I personally think that they got an unjust decision and a decision based on an unfair reading of the evidence. But this is one that when the Office of Federal Acknowledgement was asked to testify earlier about a bill to recognize Burt Lake, they said that basically they had no objection to the legislation. I think that Congress needs to perk up its ears when they hear that and say this is somewhere where we need to step in. And even though the BIA is saying they couldn't be recognized under the process as it's currently standing, we need to step in and do it because it's the right thing for the government to do.
I like you, Mr. Austin. Time for humor. I recently had an interview with Steve Colbert, the Steve Colbert Show.
Oh, yes.
You might want to look at it. Very interesting. What I wanted to say was that I think it was Shakespeare's play, Henry VIII, that said the first thing that we do, we kill all the lawyers. I wanted to say the first anthropologist I catch coming to my islands, I want to shoot him.
I had heard that before the hearing today, and I was a little, I was thinking about changing my profession before I spoke, but I stuck with anthropology.
That's okay. That's why I like you, Mr. Austin. We have had enough anthropologists coming to my islands and studying us like we're some specimens for some scientific study for human beings or not. But at any rate, I like you. I think you're a good anthropologist. But the ones that I've seen coming to my islands, I'll shoot them the first chance. Anyway, thank you so much. Mr. Lawson.
Well, Mr. Chairman and members of the committee, I also thank you for providing me with the opportunity to provide testimony today. I'm a historian and a senior associate.
You too.
Yes. With Morgan Angel and Associates, which is a public policy consulting firm here in Washington. And I'm offering my comments today not as a representative of any organization or group, but rather as a professional researcher or consultant who has been deeply involved in issues regarding federal tribal acknowledgement and recognition for more than 23 years. My background and experience has allowed me to gain a broad perspective on these issues. For nearly 10 years, I served as a historian in the Bureau of Indian Affairs branch of Acknowledgement and Research, where I helped to evaluate petitions and also participated in the process of revising the federal acknowledgement regulations. Steve and I worked together for a brief time. I was leaving the Bureau about the same time that he was coming into the branch. Since my retirement from the federal government in 1993, I have provided consultation and research to dozens of tribal groups to assist in their pursuit of federal acknowledgement and/or congressional recognition. I've also provided research and consultation to interested parties in the tribal acknowledgement process, including state and local governments and law firms. I support H.R. 2837 in principle as a generally well-conceived plan to revise and hasten the federal acknowledgement process and also to bring it under statutory law. However, I think that the proposed legislation could be improved along the lines that I've recommended in my written comments. As I describe in detail in my written statement, the fundamental problem, and I think a lot of people have touched on it here this morning, with the Interior Department's current process is a lack of resources. The task of fully documenting a petition for federal acknowledgement is beyond the physical and financial capability of the vast majority of unrecognized tribal groups. At the same time, the Interior Department has not provided sufficient resources to evaluate petitions in a timely manner. In fact, when I consider other administrative procedures in government, I can't think of any one that takes as long for petitioners to get a final decision. Certainly broadcasters can get a license to broadcast from the FCC. Drugs can be approved by the Federal Food and Drug Administration in a fraction of the time. Whether or not the proposed legislation can succeed in streamlining the acknowledgement process also comes down to a question of resources. The provisions of H.R. 2837 have the potential of vastly improving the process, as well as bringing it to closure. However, in my view, this legislation can only reach this potential if Congress provides generous appropriations. For that reason, I recommend that the proposed legislation specify an initial budget for the Commission on Indian Recognition, as well as the amount to be initially appropriated to the Department of Health and Human Services to aid acknowledgement petitioners, both of which should be based on a realistic needs assessment, perhaps developed by the Government Accountability Office. In order to be a maximum benefit to petitioners, I recommend further that the department establish a grant program that is not fiercely competitive, but rather one that would be fairly generous in providing limited seed money to a majority of petitioners. Those petitioners that make progress demonstrable to the department with their initial grants should then be made eligible for implemental increased funding. In order to keep both continuity with the current process and to meet the demands of its ambitious schedule, I also recommend that the proposed legislation specify that the Commission would have its own legal and research staff consisting of an Office of a General Counsel and several teams of cultural anthropologists, genealogists, and historians. In my opinion, the timelines set forth in the proposed legislation are overly ambitious and problematic. The majority of petitioners would not be able to produce a documented petition within 8 years unless they receive substantial funding. The Commission would face a Herculean task in trying to resolve all of the pending documented cases within its first year, as well as all of the remaining cases within its 12-year lifespan. In a hypothetical scenario I describe in my written comments, the Commission might face a potential docket of as many as 386 cases that would have to be resolved in 12 years. This would require an average of 32 decisions a year, or approximately one every 8 working days. Federal acknowledgement of a tribal group can have a significant impact on surrounding communities, including neighboring tribes and state and local governments. Because of this potential impact, interested and informed third parties have played a key role in the acknowledgement process in supporting, monitoring, and opposing the federal acknowledgement of tribal petitioners. H.R. 2837 gives the appearance of having reduced the role of interested parties in the acknowledgement process. For that reason, I would suggest that the committee consider revising the language of the bill to give interested parties a role in nominating commissioners, participating in all hearings, and appealing final determinations. Finally, because litigation is also expensive and could be beyond the means of most petitioners, I do not favor a provision for an appeal of the Commission's final determinations to the U.S. District Court for the District of Columbia. Instead, I recommend an appeal process to an independent panel of administrative law judges dedicated to the purpose of hearing federal acknowledgement appeals. This concludes my statement. I'd be happy to answer any questions that the committee may have, and I would also be willing to submit further written comments to the committee upon request.
Thank you very much, Mr. Lawson. Mr. Cramer.
Thank you, Mr. Chairman, members of the committee. I certainly appreciate the opportunity to testify. I'm David Cramer, legal counsel for the Confederated Tribes of the Lower Rogue. With me today is Donny Fry, who is the chairman of the Tribal Council. The Confederated Tribes of the Lower Rogue is an entity composed of Chetco and Tututni tribes residing in their homeland in the Rogue River Valley in southwestern Oregon. In the latter part of the 19th century and the first half of the 20th century, the federal government maintained a regular relationship with these tribes, just as it did with many of their sister tribes in Oregon. But that all changed in 1954 when Congress passed 25 U.S.C. 691-708, commonly known as the Western Oregon Termination Act. This sweeping act terminated all federal relationships with, quote, any of the tribes, bands, groups, or communities of Indians located west of the Cascade Mountains in Oregon, and went on to list dozens of tribes by name, including the Chetco and Tututni. This enormous social experiment was part of a social policy of the day that could be summarized as kill the Indian to save the man. There have been 5 groups of Oregon Indians who have been able to overturn this act and win restoration for their individual tribes. In passing those restoration bills, this committee had opportunities to evaluate the Western Oregon Termination Act. This committee's conclusion was that it was a complete failure with disastrous consequences for the tribes who were given no opportunity to defend their standing but were terminated solely because of geography. The Western Oregon Termination Act is not merely a dark chapter in our nation's past legal history. For us, the termination era is happening right now. For the last 10 years, the Confederated Tribes of the Lower Rogue has been seeking restoration of the relationship the Chetco and Tututni tribes held with the federal government before termination. We've been told time and again that Congress is no longer as receptive to requests for legislation granting federal recognition because an administrative proceeding through the Office of Federal Acknowledgement has been established for that purpose. The problem for us, though, is that the regulations governing the Office of Federal Acknowledgement specifically exclude tribes that have been terminated by act of Congress. That's 25 CFR 83.7G. Of the 7 criteria that have been talked about, that's criterion number 7. We are ineligible to apply for acknowledgement through the Office of Federal Acknowledgement. We can't even get on the waiting list. Likewise, if we turn to the bill under consideration here today, Section 5, subsection A, sub 3, sub D, contains the same exclusion language. So even if this bill passes, we'll still be left out, still barred by an unjust and racist 50-year-old law that should never have been enacted. So we're not here today either to support or oppose H.R. 2837 as it is presently written. We're here to ask for your help. 5 times between 1973 and 1989, you and your predecessors who sat in those chairs in this committee condemned the Western Oregon Termination Act in the strongest language. But we now have before us a bill that would in effect ratify the Termination Act and essentially give it a stamp of approval as though it were not an unjust law, because it would again close the door to any terminated tribes, just as the existing OFA procedure does. So I'm here today to ask, what remedy can there be for us who are still living in the era of termination? And I'm not really sure what that is. Possibly an amendment to this bill. If it is an amendment to this bill, maybe there could be set up a separate procedure for tribes that were terminated.
Mr. Cramer, so that I won't lose my train of thought, what do you think of just simply rescinding the law?
Well, I think that's a wonderful idea. If the entire Western Oregon Termination Act were simply repealed, that would be a good start. Although I'd have to say then our next step, I guess, would have to be to get in line and start a petition with the Office of Federal Acknowledgement. That's a daunting task because we'd have to get in line behind everybody else. And just as has been mentioned by some of my colleagues on this panel, I don't think we can afford it. It took most of this tribe's available cash to provide the plane tickets for Mr. Fry and I to come here today. I represent this tribe pro bono as best as I can and still provide for my family. We don't have $8 million.
I'm sorry, I didn't mean to interrupt you.
No, that's quite all right. I was actually about wrapping up.
Your testimony hit me like a rock here.
Yeah.
In terms of saying, can you share for the record what surrounded this whole idea of terminating the Oregon tribes? I mean, why did Congress pass this law 50, 60 years ago?
To tell you the truth, I'm not entirely sure. The social policy of the day was termination, that by wiping out...
No, first it was to kill the Indians.
Yes.
Then assimilate the Indians.
Yes.
Then terminate the Indians, and now recognize the Indians.
Right. The research that I've been able to find on the legislative history research and so forth, and I'm not a historian, maybe I should ask a gentleman like yourself, on that act itself is not too extensive. I'm not entirely sure what prompted it. As far as I can tell, there was really no input whatsoever from the terminated tribes themselves.
I'm going to request staff that we put this as a matter of history, finding out exactly what prompted the Congress at that point in time to specifically pass a law to terminate the tribes of just your state. I'm curious why pick on Oregon? I thought maybe it was flat out everybody's to be terminated, but to say that this was done specifically against the Oregon tribes, that surprises me.
I know of other termination laws, but I don't know of any other sweeping laws like that just an entire geographical area, all of the Native Americans in it, none of you exist anymore. I think that law is somewhat unique, and the legislative history for the Restoration Acts, this committee had in its reports discussed that law in more detail and said that apparently its intention was that it would essentially force an assimilation into white society, that it would alleviate poverty somehow. Obviously, it had the reverse effect of that, and that was the committee's finding on each of the times of these Restoration Acts came up.
I can provide some analysis.
Please, Mr. Lawson.
To that, in the screening that the Bureau of Indian Affairs was doing during that time of tribes who were eligible for termination, was that whether or not they had enough resources that they thought that they could be that they could become essentially a county government, that they would be self-sufficient based on the resources they had, and that's the first tribes that they targeted. And
that was the first mistake.
And tribes like Menominee in Wisconsin and in Klamath in Oregon, but other tribes primarily based on their timber resources were added to that list because they thought that they could be self-sufficient and thrive without government aid based on having these resources.
I could add also that there was a Western Washington termination bill, but it was never passed. It was proposed but never passed. So as a point of contrast, you might want to look into why one was passed and one wasn't. But I'll tell you what I think is most frightening about the termination era is I'm hearing discussions now from the current administration that filter into the recognition issue of trying to limit the federal government's responsibility and liability to Indian tribes. And one of the outcomes of that, I think, and some of the decisions that we've seen recently, is to damper the number of new tribes that are going to be approved because they simply don't want to have more responsibility and more expense caused by having more tribes on the recognized tribes list. I think this the termination, while it was first proposed 50-some years ago, I'm afraid that we're seeing it raise its ugly head again in the current day. And this is something to be very aware of because I don't think Indian tribes are necessarily taking it in quite as strongly as they need to. I'm not hearing enough outcry from Indian country as much as I think is warranted on that issue.
Isn't it ironic that it was President Nixon that was pretty much probably one of the few presidents that have really been a great advocate of Indian rights and the problems in the mid-'70s. And now how ironic that it was a Republican administration that is trying to get rid of the Indians, or at least have at least responsibility to provide for their needs. I'm sorry, Mr. Cramer, I didn't mean to interrupt your statement. Are you through with your statement?
I was just at the close of my statement. Thank you, sir.
All right. I just want to ask the members of the panel, I really appreciate the recommendations and the suggestions that you offered. Definitely the staff and myself and other members of the committee, Chairman Rahal and Mr. Cole will definitely review some of the suggestions that you're offering here. I don't know when we're going to be putting this up for markup, but I sincerely hope very soon, in a way that we might get some more positive results in response from the Department of the Interior, and then hopefully by then we will have the official letter from the Department of Justice challenging the constitutionality of the right of Congress to pass legislation to provide for the needs of Native Americans. I'm very curious about this. But gentlemen, I cannot thank you enough for being here. I hope that in maybe another time we will have another hearing on this issue, if there's still going to be more questions that maybe some of the members may want to raise concerning this proposed bill. And again, I cannot thank Chairman Rahal for his leadership in finally taking this issue more seriously than ever, and that by the fact that we're holding this hearing, to me, is a very strong indication that he really wants to do something about this, and we're certainly going to push this legislation as much as we can on this committee. And with that, gentlemen, thank you again. The hearing is adjourned.